Hello, everyone. Your screen has not frozen. I was just waiting to see how many people are joining. And as people stream in, I think we can just kick off. Good evening and welcome to the third annual Town Hall for ICC Singapore. First of all, we weren't being tone deaf in convening this Town Hall on a Friday evening. We thought we would start your weekend on a high note by updating everyone on the exciting developments at the ICC and the dynamic activities ICC Singapore has been engaging in. The most exciting development this year is the appointment of Claudia Salomon as the president of the ICC Court. She's our first female president in the institution's 100-year history. We are very fortunate to have Claudia be able to join our town hall today. She shuttles between several time zones, mostly New York and Paris, and her energy is as much tireless as it is daunting. In the short 4 months since she was appointed, it has become very apparent, to me at least, that her worldview is one that would resonate very much with the Singapore arbitration community. And I say this for 3 reasons. 1, she has a client mindset. 2, she values Asia as a key jurisdiction that the ICC should focus on. And 3, she's not willing to just accept and maintain the high standard the ICC already has, but wants to make it an even better arbitral institution that is future-proof. With that, I'm very pleased to pass the floor to Claudia to address you all directly.
Thank you so much, Smitha, and thanks everyone for joining on your Friday night. So the key points that were made by Smitha are really resonate with me, and I'll address some of them, but just want to emphasize the commitment to Asia and the commitment to Singapore. And before I begin my remarks, I just want to highlight in particular 2 key points, which is just this week on Wednesday, as you may have seen either on Instagram or on LinkedIn or other social media, that Alex Fessas, Secretary General of ICC, Tejus Chauhan, our Regional Director based in Singapore, and I had the opportunity to meet with Minister Edwin Zhang, who's the as well as the Minister of Culture and Sport, to talk about the mutual interest between Singapore and ICC. And it is very clear that we have shared interest in connecting with the business community and connecting in terms of the development of Singapore as an important hub, an important seat for international arbitration. So we really welcome the opportunity. We're honored to have the opportunity to host him along with the Singapore ambassador to France and other representatives from the embassy and the Ministry of Justice. We have, of course, have a case management team in Singapore, and our regional office is based there, and it's a very important place for us. The emphasis of Singapore is particularly highlighted because we also have now one of the vice presidents of the ICC Court, VK Raja from Singapore, as one of my trusted advisors, along with our 2 Singapore court members, of course, Smitha and Kabir Singh. And so the voice of Singapore, along with Chien Bao, who is living in Singapore, is absolutely heard in terms of the workings of the court, the engagement of what we do, and the thinking about what we do. So let me just focus on a few key points from my perspective. The first is really just talking about and taking a step back to focus on what is ICC. We talk about ICC Court and ICC Arbitration, but ICC, the International Chamber of Commerce, is the global voice of business. It was founded in the wake of World War I over 100 years ago by a pioneering group of entrepreneurs, and they were seeking to promote peace and prosperity through cross-border trade. They understood that to facilitate cross-border business, there needed to be a dispute resolution procedure that met the needs of global business. And they understood the importance of access to justice and the rule of law. And that purpose is no more true than today, because as cross-border business has continued to increase, businesses around the globe know that ICC is a trusted institution to resolve their disputes. And just briefly, today ICC is administering cases involving parties from 145 countries, 25% of which come from Asia Pacific. Arbitration awards are seated in 113 cities in 65 different countries, with awards drafted in 10 languages. And Singapore is the most important seat in Asia and within our top 10 seats globally. Parties are increasingly selecting ICC for not only their international disputes, but also domestic disputes as well. So global business is choosing ICC because they trust ICC. They know that ICC is the only arbitral institution that is truly international, not tied to any geography or subject to shifting political winds. And global business trusts ICC because they know that ICC understands the needs of global business. And as Smitha identified, my focus is assuring that every aspect of international arbitration indeed has this client mindset. So what do we mean by that? Of course, outside counsel representing a party in an arbitration has a client, but the arbitral institutions and the arbitrators have clients too. For purposes of the mindset, the parties in the arbitration must be thought of as our clients. We have to be focused on ensuring that the parties, essentially our clients, are the ones driving the service requirements. Richard Susskind, the prolific author and member of ICC's governing body, has explained that when people visit a neurosurgeon, they don't want surgery, they want health. And surgery happens to be the means by which they hope to achieve that objective. So likewise, when parties are in a dispute, they don't want an arbitration or a litigation. They want a resolution of that dispute. And arbitration or litigation happens to be the means by which they hope to achieve that objective. What they're looking for is an opportunity to identify ways in which they can get to that resolution. Before stepping into this role as president of the ICC Court, I served as outside counsel for over 25 years. And I was always talking to my clients about what is their objective. This was at the beginning of the case and throughout the case. What is the objective? How can we design our strategy to meet those objectives or shift our strategy as the objectives may shift as well? So from my perspective, the best way to identify what parties want in each particular case is to, and improve our ability to respond to those desires, is to engage the parties themselves more deeply in the arbitration process. This way, the parties have more control over the way in which the resolution of the dispute unfolds, and I believe there's going to be better alignment between what the parties expect in an arbitration process and the actual process itself. Given the expanded role of in-house counsel over the last decade to more of a strategist and risk manager, we have the opportunity to ensure that the arbitration process better reflects that role. We know today that general counsel are primarily counselors to the CEO and the board of directors. They play a vital role in devising and implementing strategies and operational objectives to create value, to work hand in glove with the business team, rather than, in essence, the office of no, once the business team has developed the strategy and then the legal team historically has focused on assessing whether such a strategy could go forward. If we bring the general counsel, the in-house counsel, into the arbitration process, they're able to make calls in real time, and they can have more control over and input into the way the process unfolds. So let me just offer a few thoughts on this, and I welcome your thoughts on how we can improve these processes and engage in-house counsel more in the process. First, at a really basic level, I think we can start by asking in-house counsel if they want to be copied on all communication. This isn't to say that they're then going to start speaking at hearings or be in conflict with their outside counsel. Instead, it's inviting them in. And it also has the added effect of having the institutions and the arbitrators aware of the clarity and structure of their own communications, knowing that the end users, the parties, are receiving that information, and they won't be relying on outside counsel to, in essence, translate what's being said for an understanding of in-house counsel. Second, we want to encourage in-house counsel to participate in case management conferences or preliminary hearings. And I know from recent experience, when chairing a tribunal, that having in-house counsel present enabled us to resolve what really was a minor dispute about timing of the evidentiary hearing. But we were able to do that right away because we were conducting the preliminary hearing through video conferencing, much like this. And so I was just able to ask everybody to go on mute, and counsel could speak with their clients, and the issue got resolved instead of having follow-up emails and subsequent communications. And so that was just so much more efficient. Third, we don't want to think about the procedural timetable as written in stone. Instead, if the procedural timetable in an arbitration has flexibility and adjustment without unnecessary postponement, there may be situations in which a hearing can be shortened, or certain matters can be resolved more efficiently on the papers, or the parties want timeframes built into the schedule. So I was addressing this issue in a keynote earlier this week, which is essentially to focus on the issues in dispute, not just at the beginning of the case, but throughout the arbitration. And again, with utilizing technology, we have the means to hold case management conferences multiple times throughout the arbitration. So, for example, not just at the beginning, but after the first round of submissions, before document requests, if that's the order in which the timetable will take place. It may be that the issues in dispute have shifted, and before the tribunal has to make calls about which documents are relevant to the outcome of the case, it's important to have clarity with regard to what actually are the issues to be decided. And that can be addressed through periodic case management conferences at the beginning, before document production, at the beginning of the evidentiary hearing, and at the end of the evidentiary hearing, before the tribunal goes into deliberations. Fourth, we want to have a focus on transparency and predictability, ensuring that the parties know what to expect from the process, because it's just wrong that some parties have exclusive knowledge based on their previous experience, instead of all parties, wherever they are in the world, have accessing to information to make data-driven decisions. For me, thinking about party engagement in the arbitration, thinking about a focus on the issues to be decided, really should be part of our daily life, like brushing our teeth. But it is in so many ways like flossing, something we know we should do, but we still need to be reminded by the dentist to do. So with that, I really hope that ICC is viewed as a partner you trust when a dispute arises. Let me just close with the discussion of values. In one of my last hearings, before I stepped into this role and before the pandemic, I was working closely with an associate who has type 1 diabetes. We worked very long days in the war room as we were preparing for a hearing. And I was helping the associate get ready to take his first cross-examination as a witness. So I hadn't worked with somebody who has type 1 diabetes before. And it was eye-opening to see what he had to do to monitor his blood level, his insulin, his food intake, all in the midst of intense hearing preparations. And then we were in the hearing, and it was time for the associate to do his cross-examination. And he did such a good job, and I was so proud of him. And opposing counsel did their redirect, and they didn't really score any points, and so all went well. And then the tribunal began their questioning, and they started to get quite interested and engage with some of the issues and began to ask more and more questions. And I saw the associate sitting in the first chair for the first time begin to get very agitated. And he was looking around, and I asked if he was okay, and he said yes. And then the tribunal just kept asking more questions. And suddenly the associate ran out of the room, and the tribunal looked askance, and I assured them that they could continue. But to this day, I regret what happened, because if I had only said to the tribunal at the start of the hearing that we may need to ask for a break at what might seem like an inopportune time, but I can assure you that it is for the health of my team and not for strategic reasons. I hope that will be okay. I know that the tribunal would have said, of course. And I would have shifted the burden from the associate who was too worried about losing this opportunity to advance his career and get the experience of cross-examining a witness to raise this issue. And I could have pierced the silence that has lasted too long. So now, as an arbitrator, I include as part of the agenda at the preliminary hearing a question whether there are any disability inclusion issues we need to consider. And it's a question that needs to be asked at the start of the hearing as well. And that is the reason the ICC announced during my first week in office the creation of the Task Force on Disability Inclusion and International Arbitration. Businesses around the globe, from multinationals to SMEs, small and medium-sized enterprises, recognize the value of diversity, and they recognize the value of inclusion. And businesses increasingly are choosing to do business with those who share their core values. And as the president of the ICC Court, I am focused on assuring that our dispute resolution services meet the needs of global business. And we have the strong partnership built on shared values. So I thank you so much and look forward to working with you and hearing from you.
Thank you, Claudia, and greetings everyone also from myself, from a sunny, as you perhaps can see behind my virtual background, and very cold Parisian morning. It's a great pleasure to be able to reconnect with many of you, and those that I do know and those that I will have the opportunity hopefully to meet today. And during my first trip in Singapore in 2 years, more than 2 years time, which I hope to be able to have in the beginning of 2022, to Smitha Harris and the whole group, leadership group of the Arbitration Committee of ICC Singapore, a warm thanks for putting this meeting and this event together. In the few minutes that have been allocated to me, I would want to focus on a couple of key updates with regard to the work of the Secretariat and the ICC Court. It would be perhaps remiss of me if I didn't start by mentioning, albeit briefly, how challenging the past year has been, as the year before it, with regard to case management, operations, business development, trainings and conferences, due to the pandemic, but also importantly, the consequences of the pandemic. I think the big difference between 21 and 2020 is that we learned to live with it, but basically we also had to manage as a community and also individually the effects of that pandemic as much as the pandemic itself. I think the Secretariat managed to come out of that successfully. We saw a rise in cases last year, which was an actual rise in single individual registrations. It was a very successful year for the Secretariat and the Court. We saw an increase in the number of pending cases, due partially at least to the fact that procedural calendars were extended to take into account the fact the adverse effects of the pandemic. And we also saw a more pronounced need of coordination between the offices of the Secretariat across different continents, including, of course, the office in Singapore. We did learn a lot through that, and I think we also tried from the very start to ensure that whatever guidance that we could have shared, and when we did in fact share during the first months of the pandemic, would actually be made available to all stakeholders within a dispute resolution process for their own consideration, reflection, and ultimate use. That is why as we had discussed last time, the Secretariat's guidance with regard to possible ways of mitigating the adverse effects of the pandemic in dispute resolution was ultimately consolidated into our note to parties and arbitral tribunals on the conduct of the arbitration. That is why ultimately the rules revision that had already begun prior to the pandemic hitting us in March 2020 also took stock of some of those points. And that is why we also engaged in a very, I think, pronounced campaign of sharing that information across multiple fora to make sure that those techniques would actually be utilized in the most positive manner. To this day, I must say that we have not seen an award be set aside because a tribunal may have decided to switch its setting from an in-person physical setting to a virtual setting. To this day, we have not seen much opposition for at least procedural conferences to be held virtual. There is debate, of course, as is expected in any given case, to a certain extent, with regard to the parameters of the calendar, to the parameters of hearings, the extent, the logistics, and so on and so forth. And I think this, again, is part of the consequences of the pandemic that we will need to live with for some time. There is work, of course, that both the Secretariat, the Court, and the ICC Commission on Arbitration and ADR are doing in this regard, and perhaps there will be more coming out of the Commission before the end of the year. Let me move, of course, beyond the pandemic, which is, I think, the area that we should be focusing on a bit more attentively. I mentioned the rules and the rules revision. Again, this was not a cosmetic revision of the rules. There were important points, as always, that have come out of practice that needed to be crystallized and recognized, acknowledged in the context of the rules proposition. And there are items there. I won't go, of course, into detail, but there are elements that speak both towards complex arbitration, the constitution of tribunals, the ability, of course, of tribunals to set the procedural parameters of a hearing in the absence of parties' agreement, specifically with regard to hearings, and importantly, elements of transparency, both with regard to the operations of the Court and the Secretariat, but also with regard to its decision-making. And I must say that the focus on transparency is an element that is quite pronounced in the ICC Dispute Resolution Services proposition, and it will remain one for years to come. Indeed, it will be expanded progressively, and I'm happy to expand on that if time allows. The publication of awards project, which is something that as you may recall, we launched in early 2018 or late 2018, early 2019, has kicked off officially in April this year. Obviously, the interim period was a period in which we wanted parties to become accustomed with the fact that awards may be published and to seek the guidance with regard to the best way to implement this engagement that the ICC Court had taken vis-à-vis all stakeholders. And it also required careful considerations of the point that we would, of the different points that we as an institution would need to consider in order to make sure that that process that leads to the publication of an award is respectful of the parties' intentions and, of course, of the quality of the service that we provide. There are a number of awards that have already been made available under this project, under this service, if you like, under the collaboration between ICC and Jus Mundi. Importantly, and this is again the emphasis on transparency that I mentioned a moment ago, this service is provided freely to anyone who is interested. Of course, users may then, users of Jus Mundi, subscribers of Jus Mundi may then, of course, rely on the expanded services of that database to cross-relate information from awards with other available resources. I'm hopeful that by the end of November, we will have been able to publish a total of 25 awards in the context of that collaboration. And it is quite telling that as we have better understood how to manage this transparency initiative, parties have also become much more comfortable with publication, even in situations where the awards are confidential. So I'm quite hopeful that this is something that will pick up significantly in 2022. And I'm equally hopeful that other arbitral institutions will also consider this possibility to the extent possible. Moving closer to the operations of the Secretariat, 2021, albeit again a year of pandemic intensity, was also one where the Secretariat did not cease to expand its operations and services. So in full pandemic mode, we actually opened up our latest case management office in the United Arab Emirates, specifically in Abu Dhabi Global Market. We, as you may recall, we already had a representative office in ADGM for business development purposes, which has now been complemented by a full case management team that is busy administering cases seated in the United Arab Emirates and in neighboring jurisdictions. There are additional elements that speak to an investment that the Secretariat is making to ensure the viability of its operations, both on case management on the one hand, but also on business development and marketing and promotion on the other hand. I'm hopeful that when I will be seeing most of you in person in a few months in Singapore, I will have the possibility to discuss these plans, which are in the process of being implemented now, more in detail. But I would like to close without taking more of your time, given that I have spoken of business development, of the importance of Singapore for ICC, and hopefully the importance of ICC for Singapore. And I do believe that this is a mutually beneficial relationship which really passes through all your hands, the arbitrators, the experts, the corporate counsel, and indeed the law firms. And to all of you who have very generously accepted to participate at this meeting this Friday afternoon or evening, I would like to take the opportunity to present to you Tejus Chauhan, who is our Regional Director for Southeast Asia, who will be based in just a few short days after a long odyssey that took him from Delhi to Paris and ultimately will lead him to Singapore, taking up and picking up the baton from Abhinav Bhushan, who, as you know, completed his mission as our Regional Director earlier this summer. Tejus is in the process of constituting a team that will complement his activities in Singapore, in India, and a number of other jurisdictions in Southeast Asia. I would warmly invite you to get in touch with Tejus as soon as he has arrived or settled in Singapore in the month of December. And again, thank you all very much for your attention. I look forward to engaging with you very much in the next few months.
Thank you, Alex. I must confess that when I took this job, the thought of filling in the big shoes of my predecessor, Abhinav, and going beyond the work that has already been done did cross my mind. However, I was comforted by the fact that I had the advantage of being mentored by Abhinav and you earlier, and of course, had the support of the members of the arbitral community in Singapore and India particularly. I continue to count on that support and move on from here on. A very warm welcome to the audience and our gratitude to the SPF team and ICC Singapore Arbitration Group for organizing this town hall. Claudia and Alex spoke about the importance of Asia, Singapore, our rules, and I just wanted to touch upon some of the other important areas we're working on in Singapore, which might be of interest to the audience. Number one is increasing our footprint that Alex just mentioned, and manpower on the ground. Now, we do have a case management team which is working with full force and full strength. And as it sets out to develop further, we are increasing our business development team as well. To that effect, we are currently hiring for the position of Deputy Director, which is based out of Singapore. The position applications are open for the position until the 30th of November. And may I please request you to encourage those who are suitable to apply. We will also hire for other jurisdictions in South Asia, and the information on that will be out in due course. We also have 3 ICCF representatives from Singapore, and you will hear on that later from Arthi. The importance of Singapore is demonstrated by the fact that Singapore, apart from India, is the only jurisdiction in Asia to have more than 2 ICCF representatives. We look forward to engagement with the younger practitioners in Singapore and beyond, and count on your support for that as well. Speaking in terms of the events that we organize, and I'm conscious of the fact that we've had a lot of events and we've had a lot of webinars, and there is a general webinar fatigue, and we hope to get back to physical events. The ICC Court organizes its annual Asia conference, which shuttles between Singapore and Hong Kong. We've had the support of the Ministry of Law for that as well in the past. And the virtual conference, which took place last year, was anchored out of Singapore and will be back again to Singapore in 2023 for hopefully a physical event. In 2022, next year, the conference goes back to Hong Kong, and we hope to see you there. We also have the ICC Indonesia and ICC India Arbitration Day on the 26th and 27th of November. Networking and meetings are important. And in that stead, I would also like to focus on the importance that we place on meetings. Last week, we had an in-house counsel roundtable, which was attended by Claudia and Alex, and something that the ICC Singapore Arbitration Group organized for us. And in that meeting, we addressed issues of the in-house counsels in terms of their expectations from the dispute resolution process, their feedback on ICC arbitration, and just gave them a sense of, how does institutional arbitration work? What are the costs involved? There are, of course, a lot of myths and misconceptions. A lot of questions regarding cost, regarding case management, and that is something that was addressed. Claudia and Alex have mentioned it before, and I'd just like to reiterate that if there is a session that you would like us to organize for your team, for your clients, we would be very happy to do that and support you. Lastly, I look forward to being in Singapore next month and meeting all of you in person. If there is any assistance that you would require from the court or myself, please do not hesitate to reach out, WhatsApp, call, or drop by at our office in Maxwell Chamber. Until then, thank you so much and wish you all the very best. Caris, may I now invite you for your remarks.
Thank you so much to Claudia, Alex, and Tejus for sharing the vision and very meaningful work of the ICC. I think, needless to say, we look forward very much to welcoming you to our sunny island that is not cold, not quite as cold as Paris, at least. So for the next 10 minutes or so, I will be giving you an update on the activities of ICC Singapore. But as Sapna typed in the chat, if you have any questions at any point, please feel free to type them in the Q&A box. We do have a Q&A session at the end, and we'll be happy to address your burning questions. So first, let me start off this update on activities. I'm only the mouthpiece. This is actually the culmination of the work of 7 committees, 9 co-chairs, 28 committee members, and all led by our fearless leader, Smitha Menon, chair of the ICC Singapore Group, and Andrew Yeo, our vice chair. So it's been a mammoth task trying to compile the number of events that ICC Singapore has planned and that are forthcoming. So I'm going to summarize, but what we will do today is only to give you a flavor of what we have been up to. If you want details, you yourself should get involved, join the events, get in touch with us. So let's, without further ado, talk about what we've been up to. We were off to a little bit of a shaky start, adjusting when the pandemic first hit in early 2020, but since then we have gathered steam. Our events have centered around engagement. That's really engagement with our users, the business community, regional bodies. You heard quite a lot about that from Claudia, from Tejus. Enrichment, education, knowledge sharing, legal updates, and enjoyment, which is what we all like, fun events. Let's start with engagement. Now, this part really dovetails with what Smitha and Claudia shared about the client-centric focus, right? It's been about engagement with the business community, the intention being to reach out to businesses, actual users of ADR services, to help them understand how ADR fits in with the commercial practices in the current climate. So just last month, our Business Community Outreach Committee, that's quite a mouthful, but our Business Outreach Committee organized a webinar titled Taking the Bull by its Horns. This was for the Association of Trade and Commerce, and it explored various dispute resolution mechanisms, obviously focusing on the options offered by the ICC. Another example, Tejus already mentioned it, our roundtable. I hear that the discussion was so rich and so engaging that they ran out of time, and clearly they were very upset to have to say goodbye. Now, enrichment. In December last year, and this is our fun, cool committee, the Next Gen Committee, organized a career event. It was called Arbitration Career Choices, swipe left or right, something that some of us might be familiar with. That was a webinar on the roles and opportunities available to new law graduates and lawyers in the world of international arbitration. The other one, another example, is the webinar on the new ICC Rules 2020, led by none other than our Thought Leadership Committee. More than 80 attendees participated, and they covered everything from complex arbitrations, transparency, tribunals, powers. Now, the most important part, which we like, enjoyment. These are fun, light-hearted events, really founded on our friendship and fondness, if I may say, for each other. This includes our Arbitrators Studio series. This was led by the Opportunity Events Committee, and they invited big names like Gabriel Kaufman-Kohler, Chris Thomas, and the intention is for them to hold no-holds-barred, frank, interactive, candid sessions. So if you have embarrassing questions to ask, this is where you ask them. So apparently for the recent one with Chris Thomas, they had 85 attendees. So not quite intimate, but maybe popular is the right description. The committee also intends to move this back to a hybrid format once COVID restrictions allow for it. And I'm sure all of us are waiting with bated breath for that. Now, looking ahead to 2022, engagement. We will be co-organizing a virtual seminar on the first 100 days in a dispute. This is targeted at in-house counsel with no background in dispute resolution. And the idea here is a combination of education, but also it's sort of a playbook of top tips for dispute management. Now, some of you may have also seen the flyer go out yesterday for Arbitration in Asia, practical tips from across the region. I understand that experienced practitioners are going to be sharing war stories from over 30 years of challenges. So if you want to hear what battles and war is all about, I think that's the one that you're going to want to tune into. Now, the APAC network is also planning to be part of the 7th ICC Asia conference. So that's in June next year. Block your calendars if you're interested. If you want to be enriched, we have a virtual panel discussion on the subtle and not so subtle differences in how negotiation, mediation, and arbitration are dealt with in Asia, and an open mic session. That's where we're going to allow users of ICC arbitration to air their comments and criticize us and face up to that, but look for ways to improve. Now, finally, on enjoyment, we have a mood competition coming up for younger practitioners. This will not only be a chance to hone their advocacy skills, but to network, to have fun together, learn through doing, right? The Next Gen Committee is also organizing a debate on whether youth trumps experience in international arbitration. I hope the audience gets to vote on that one. The APAC Network Committee is also setting up Twitter and LinkedIn accounts, so please link up with us when they are up. So finally, these are our heroes, starting from the far left, the Business Community Outreach chaired by Margaret Joan Ling, Regional Projects co-chaired by John Choom and Kelvin Poon, APAC Network chaired by Alvin Yeo, Next Gen chaired by Matthew Seacombe, Thought Leadership co-chaired by Paul Sandosham and Au Kim Kit, Opportunity Events co-chaired by our heroes who are appearing a second time, Matthew Seacombe and Alvin Yeo. And then finally, the Townhall Committee. You see us once a year, but outside of the Townhall, we're always happy to say hello, have a coffee, give you a hug, and give you big smiles. That's Sapna and myself. Finally, and I'm going to close with this, it is really up to us to create a very dynamic and great community that we want to be a part of. So if you allow me a plug, get enthusiastic, get connected, and get involved. If you're interested, please email iccsingapore@sbf.org.sg and do that before you welcome 2022. Now, I will hand over to Aarti, who is going to give us updates from the ICCYF. Far more exciting, fun stuff from the younger people amongst us. So Aarti, over to you.
Thanks, Karis. Hi, everyone. It's a pleasure to be here today. My name is Aarti, and I am one of 3 ICCYAF representatives from Singapore for 2021 to 2023. My co-representatives, as it were, are Dimitrios Katsikis and Akshay Kishore. Now, what is ICCYAF? Now, the ICCYAF, which stands for the Young Arbitrators Forum, is a global network of professionals aged 40 and under, comprising of young arbitrators or aspiring arbitrators from all over the world. The YAF network is spread across 7 regional chapters. So we have chapters in Africa, Middle East and Turkey, North Asia, South Asia, Europe and Russia, Latin America, and North America. Now, the group is expansive and diverse. And this year, I understand that the group of representatives comprises 48 women and 41 men. The representatives from Singapore are part of the South Asia chapter. Now, YAF, the primary aim of this network is to provide young professionals in the field of arbitration and generally in dispute resolution with opportunities to engage with fellow like-minded practitioners, to discuss topical issues, to learn about best practices, to learn about the ICC's dispute resolution services, and essentially to get a more unique and practice-based understanding of international arbitration, and ultimately to develop a network of professional relationships that extend far beyond borders. And so this is ordinarily achieved through the organization of events, through social activities, talks, and seminars, as you have it. Now, the network's key or flagship event is what is known as the biannual ICC YAF Global Conference, and that brings together all the representatives around the world. The global conference this year concluded recently between 28th to the 29th of September. And this year, the event was conducted in a very special way. In view of global travel restrictions due to the pandemic, the global conference was an online event that ran for 24 hours. So I believe it started at 3 p.m. Paris time on the 28th, and it concluded at that same time on the 29th. And each chapter took control of a segment of this 24-hour period and organized activities like dialogues, talks, debates. All of these segments were accessible to members from all over the world. And it was the fact that it was a 24-hour online conference was a unique solution that really circumvented the restrictions we face today travel-wise, and it was very inclusive. The South Asia chapter had an interesting debate on the independence of party-appointed experts, and it had a segment on tips for young practitioners from young practitioners. So that was a very interesting perspective that was put forward in the conference. Now, as incoming ICC YAF representatives, what do Demetrius, Akshay, and I seek to achieve? In discussing a plan for to take this forward, we identified 3 groups of individuals that we want to engage with during our term. The first is actually the student community, who will at the end of the day be the future of our industry. We want to tap on the potential of this group early on to cultivate a sense of interest in the practice of international arbitration, play a role in developing substantive knowledge of the practice, shedding light on the role of ICC in this field, and providing insight into the tools and the resources that are available from the ICC. The second group we want to engage with is young arbitration practitioners. Now, we want to focus here on honing their substantive knowledge of arbitration, but also giving them the opportunity to interact with practitioners, both young and seasoned, to get a more holistic perspective of what practice really entails. And the final group, and I think this relates a lot to what Claudia also said today in the speech, is that we want to engage with corporate end users. We want to engage with in-house counsel, yes, of course, but also with members of business teams themselves. We want to have opportunities to demonstrate to these individuals the attraction of international arbitration, the prominence of ICC in the field, the services that ICC offers, to show that ICC is a tool that helps businesses work and that businesses can rely on for the smooth management and the resolution of disputes. And so we come in with maybe very lofty ambitions. We hope to do what we can to engage these groups of individuals over the next 2 years in conventional ways and perhaps also in non-conventional ways. And we are definitely open to collaboration and working together with members of the ICC group here. So please, at any time, feel free to reach out to any one of us if you have ideas or if you want to collaborate together. And we look forward to working with you at some point. That's all from me. I will now pass on to Andrew.
Thank you, Arthi. I'm speaking for the selection committee. The selection committee, of course, is a group of people who help with the Secretariat in terms of nominating suitable candidates for appointment by arbitration as arbitrators by the Court of Arbitration. The committee consists of 5 persons. It's chaired by Smitha, and the other 4 members are myself, Anne Seacombe, Kelvin Poon, and Paul Sandersham. I thought it'd be useful to just give a simple reminder about our processes and an update on the stats in terms of how we've done in the last 12 months. So the simple process really is divided into 6 steps. Essentially, it kicks off when the ICC receives a request from the Secretariat to nominate an arbitrator for a specific case. Certain information on the case and the financials will come to the ICC. Next, the ICC will forward that to the members of the selection committee. Based on the case information and acting in accordance with the note to national committees from the ICC, we will gather together and discuss and consider who are the suitable candidates. We'll come up with a short list, and in consultation with the counsel or deputy counsel in charge of the case, we will consider that short list and next come to an agreement on the suitable candidates. Generally speaking, we put forward more than one name in all the cases that I can recall over the last 2 years, usually about 3 all the way up to 5 per case. And once agreed upon this short list, if I may call it that, we reach out to them and get them to express their willingness, clear conflicts, and fill up the forms. The forms, as you can see in the blue box here, there's the CV, which is a template on the ICC forms, the statement, and the financials. The forms will come back to us, and it's our responsibility to ensure that they're properly filled up, and of course submit them to the Secretariat. There are 2 points that I just want to add. If there is acceptance with disclosure, we will have to make an assessment on whether or not there is sufficient cause for concern, whether there might be conflicts, and really consider whether or not that should be submitted forward. As the time availability for, especially for EP cases, whether there's good availability for the candidate in the next 6 months. The court will then consider the nominations. Quite often the court asks different national committees for their candidates for the same specific case, and then they will make their decision on appointment. So how have we done in the last 12 months or so? Total number nominated and appointed, you see there 63 and 17 appointments. Of that, we are trying to increase diversity in the pool of arbitrators, expand it, as well as increase diversity. So those under 45, you can see the numbers 20 and 6. Those who had previously not been appointed as an ICC arbitrator, 24 and 5. And then female, we put 5 forward and 3 got appointed. Range of amounts in dispute, you can see it's quite a very wide range, in fact, from tens of thousands all the way to 370 million. And in terms of seat, majority obviously is Singapore seated, but 6 of the 20 cases which were consulted on had foreign seats. And of the 20 cases were consulted on, so 17 were appointed, which is quite a good strike rate, I guess. So that's all I wanted to do in terms of an update. And I'll just now hand it over, I think, to Sapna.
Thank you so much, Andrew. Just checking if we have any questions in the chat, and I don't see any for the moment. So I invite everyone, please do post your questions for any of our panelists. In the meantime, I have one question which relates to a really interesting development I read about recently, which is the Hold the Door Open initiative, which the ICC has conceived to encourage young arbitration practitioners in Africa. So Claudia, I'd love for you to share with our audience a little bit more about this initiative and maybe whether we may see similar initiatives in Asia.
Yes, I'm really thrilled with the launch of the Hold the Door Open initiative. I know from working in large law firms that young associates and summer associates most value the training opportunity they receive or have in a large law firm by having the ability to watch more senior practitioners argue in court or in arbitration hearings. And when young associates are on the team, then they're often also have the opportunity to attend the hearing, even if they're not participating. And seeing the end of the case is so informative for all the steps that go into the preparation for the hearing. When you see a witness cross-examined in the context of their witness statement, you have such a better understanding of what should and should not necessarily be included in a witness statement, or how words get utilized, or lawyer speak, if it goes into a witness statement, gets shaped. And so the idea is to give young practitioners in a pilot program starting in Africa the opportunity to observe hearings, either virtually or in person, when they might not otherwise have that opportunity, as an essential training opportunity. And then the program will develop so they'll have a chance to speak to counsel and arbitrators. We'll have to assess timing on that, whether that will only be at the end of the case after it's concluded, or if counsel or arbitrators may be able and willing to speak with them, not about the substance, but nonetheless about the advocacy strategy, or things that the young associates observed in the hearing, that they didn't learn in law school. And then the program will have a further component where they then share, the participants share their experiences with others in the communities and in their region. We're very, very hopeful that this is a program that will expand in Africa and expand into Asia and around the globe. What we want to do with the pilot is get it right, because there's obviously important considerations about confidentiality and other sorts of things, and the steps and assuring that counsel and arbitrators agree to have these observers. And so we want to get it right at the beginning, and then know we can expand it. I must add, my husband is a poet, and he came up with the name. So really, he was so attuned to making sure we didn't refer to something as, a shadow program, which really has references to, being in the dark and secrets. And the whole idea is to hold the door open for the next generation.
I love the name, and already look forward to a further update, maybe at the Town Hall next year, as to how the pilot has gone and when it may be rolled out a little bit closer to home. So we often have questions about the process of the nomination committee. We've got a great question that's come in, which is, does the nomination committee have a goal in terms of gender representation in their selection of arbitrators? This question echoes my own thoughts that less than 10% in terms of gender representation does seem very low in a place like Singapore. So I don't know, I see Smitha has turned her camera on. I don't know, Smitha, if you want to take this.
Yes, I was trying to go first subtly to show the gender representation on screen, but jokes aside, I think Jalita raises a really good question. And first of all, the 10%, bear in mind that it's actually on the basis of only 20 requests that have come to the Singapore National Committee in the past year. So I think we had more the year before, but this past year it's only been 20, and of which only 17 were actually, our recommendations were actually accepted. So in that sense, that 10% should be looked in that context. But as a general rule, no, there's no quota. But in line with the ICC's policies, we pay special attention to trying to propose women, as well as younger arbitrators, as well as a diversity of arbitrators, not just from the same firm or the same type of firm, but just across the practice in Singapore. As in everyone who's present in Singapore and whose CVs have been submitted to ICC Singapore. We have a database of all of that. And for each nomination, we go through that spreadsheet to come up with all the names that would fit the profile of the case. So that would include if you've stated whether you're familiar with, for example, French law or civil law, or you've done construction cases before. So that's how we try and match.
I understand. So what you're saying is there are many factors to consider, but the committee is thoughtful and mindful about diversity on all levels, including gender diversity. Andrew, perhaps you have something to add?
Yeah, I just also wanted to add that we're not only limited to the database, firstly. We do have a database. Obviously, it's a convenient tool for us to trawl through and see who has the relevant experience. But I also want to put people into the shoes of the selection committee in the sense that when a request comes, there are certain requirements that are put to us by the Secretariat. And especially for the higher value cases, quite often there is a requirement for previous ICC arbitrator experience. Now, it's our intention to expand the pool as much as possible, gender, ethnicity, whatever. But in a sense, there is if you like, an entrenched effect when the cases demand or it's appropriate to have relevant arbitrator, ICC arbitrator experience. It's something, there's a tension there, because we also do need to bear in mind the client's requirements, client being the arbitrating parties, and the committee has, as much as we can, we try to push, and you can see that without being defensive or anything, that the number of new non-ICC arbitrator people that were put forward is actually quite a lot. So that's just what I wanted to add.
Thank you so much, Andrew. I'd love to hear from Alex. And Alex, may I ask you another question, if I'm not burdening you too much, which is one of the questions that comes up, I think, every year since we've been doing the town hall, is the fact that there is a requirement that the nominations of the National Committee in Singapore, from what I understand, must be of Singaporean nationality. I had understood that this was being revisited and reconsidered. May I ask you also to please touch on that point?
With pleasure, Sadnan. Thank you for raising it. We have been looking into dusting the note to national committees on the proposals of arbitrators, because again, it's a point of practice. It's not a point of the rules, strictly speaking. So being able to actually evolve the way that that collaboration works to get the best proposals is really important. And the point that you touch upon, I think, is one of the main points. And that is there a way to depart from the nationality principle? In many ways, that was already the case for some time now. The current note, for instance, and let's just speak of practice, quite frankly, the practice has always been that if in specific circumstances, the National Committee it raises the Secretariat's attention to the fact that it's done its research, it cannot find a suitable candidate who is a national, but is aware of a candidate who's a non-national, then we have a very frank chat about it. And there have been, again, it's the exception, but there have been occasions where that candidate has been put forward. The issue we sometimes come across in that circumstance is that the National Committee of that person's nationality may take issue with the fact that they may, the way that it's currently phrased is that they have been, quote unquote, deprived of the possibility of proposing that person themselves. So one way that we are thinking of going past it, and this is the current draft that has been put forward, all national committees currently for their feedback before we finalize it ahead of the end of the year, is how to go past that. And the way that we thought about this is to make sure that national committees who actually do have an existing pool of arbitrators within the jurisdiction, spanning nationals and non-nationals, can actually make good use of that. And so we will not de-emphasize the nationality criterion, because in some cases, the Singaporean National Committee is expected to nominate a Singaporean national, because if it is a French national or a Chinese national, for instance, there might be an issue because there is an issue of neutrality in the case. But in those cases where that neutrality principle would not be infringed, by proposing a non-national. The Secretariat will flag this to the National Committee and will also invite proposals regardless of nationality. And this will apply across all national committees. This is not something that is pinpointed to this one over that one. And therefore, we hope that will create an equalizing effect, and one that will ultimately lead to even better appointments, because ultimately this is the goal. And if I may just very quickly touch upon the point of diversity, Jalita's question and the answer by Smitha, I think it's important to emphasize, of course, what we all know. Diversity is or inclusiveness is a very important component in the proposal, selection, and appointment of arbitrators. It needs to be seen, of course, in the context of the best available candidate. So in that context, there are elements of experience that sometimes may speak towards a candidate that may, on the face of it, not necessarily appear to be fulfilling diversity expectations. I think what needs to happen in order to see a better reflection of the true diversity of the Singaporean legal community is to always keep that in mind. And I say this because I was looking, as that question was being addressed, I was looking at our figures. I have current figures until the end of August of all direct appointments and appointments after proposal, and the number by NCs, and the numbers have actually gone up. We have, for instance, 41% of sole arbitrators appointed being women. We have 29% of appointments being of presidents being women. I think we have still a bit of an issue with co-arbitrators, but it seems that it's actually better this year than it was even the year before and the year before it. So if there's more that we can do in that sense from our side, we are in your hands.
Thanks, Alex. Those statistics are very encouraging. Thanks also for addressing the point on expanding the pool beyond nationals of the National Committee. We really look forward to hearing about once the draft is actually in final form and you have a new, not rules, I suppose that might be too strict a way to put it, but you have new ways that national committees will be looking at expanding the pool, particularly to take into account non-nationals. Can I just ask one question, which I know we've covered in previous town halls, and I'll keep you in the hot spot, please, Alex, if I may, which is just to clarify the circumstances under which the court will reach out to national committees, just to provide some context to the issues that we've been discussing about nominations by the national committees.
With pleasure, and I just remember that Andrew raised a point that might be important, which is with regard to ICC experience, which I'm also happy to clarify. So the court actually needs to appoint, or is required to appoint, arbitrators whenever there's failure of the parties to, there's no agreement by the parties on how to proceed. So if the parties have, for instance, if a party has not nominated a co-arbitrator in the context of a three-member tribunal, if the parties have not agreed on the person to be nominated for a sole arbitrator or a president, then in the absence of any other mechanism, we have the default provisions of the rules coming in. And the default provision is for the court to proceed with making the appointment. Now, the court will, in principle, do that in less than 20% of the cases. So ultimately the window for the court to proceed with appointments is actually quite narrow. When it is required to do so, it will, in principle, do it by selecting a national committee. And I say a national committee, and I think that's important because there are instances where it will be multiple national committees, but it's quite exceptional. And that national committee is selected on the basis of the considerations of the case, namely the place of arbitration, the language of arbitration, the proximity of parties or their counsel, and a number of other circumstances that may be more specific to this case or that. the discussion at the court is always done upon recommendation of the Secretariat, and very often there are real good discussions as to whether it should be this national committee or the other. It's not always a given. And then on the basis of that, the court decides and then invites, as I said again, in principle, a national committee. There are instances where there will be multiple ones, and that is in those cases where the court may not feel fully certain that a single national committee would be able to come up with a candidate or necessarily a reliable candidate. And again, this is not a competition. This is really an exercise in trying to identify the best candidate for the case. In that context, and for the sake of full transparency, national committees are always informed that there are other national committees also looking for candidates when we resort to more than one. There are some cases where the court will not go through the national committee proposal system. And those are cases that are explicitly described in the rules, primarily instances where a party or parties is a state or a state-owned entity. Situations where the president of the court will certify that there is a certain urgency. So sometimes if we feel that the appointment needs to be done between today and tomorrow, it may not be practical to go through that whole process. And ultimately, of course, in situations where the court is looking for a national from a country where there's no national committee, although again, that may this may be tweaked on the basis of what we've just discussed. One last point with regard to Andrew's point, if I may, Sapna. Relying on a requirement for prior ICC experience, prior ICC arbitration experience, or prior arbitrator experience is something that, if I were to do a very sincere confession, has probably been abused a bit as a requirement. And I think it's intrinsically tied to sometimes the need of the Secretariat to make sure that cases proceed smoothly with someone who will have procedural experience and substantive experience to do so. But it's primarily for the court to say so. It's not really for the Secretariat to say so. So in those instances where the letter does state that we need that kind of experience, it is actually coming from, nowadays, it's coming from the court. It's not just something that comes from the Secretariat. There are those cases of a less complex nature, for instance, and I would even say, regardless of the amount in dispute, strictly speaking, where prior ICC arbitrator experience would not be required. Obviously, someone should know, if one expects to sit as a sole arbitrator or a president of a tribunal, should know how arbitration works. And so there is, I think, a certain matching of an expectation that needs to be made there. But that is, as I just said, a call that is for the court to make and not the Secretariat.
Thank you so much for clarifying that. I think we have one final question, which I'd like to invite either you or Claudia, please, to take. And the question is this: are any specific initiatives also being considered to deal with racial diversity in arbitrator appointments?
I'm happy to address that. I mean, from our perspective, we are focused on diversity broadly defined, fundamentally assuring that the international arbitration community and the appointments of arbitrators reflects the global diversity and the global business community. So we are focused on racial diversity within particular jurisdictions. So making sure and asking national committees and appointment commissions, when they're making their appointments, to consider diversity broadly defined, which doesn't just include gender, but also includes race and cultural diversity, because obviously communities around the globe are not monolithic within their own jurisdictions. We're also very focused on consideration of geographic diversity. So this means that while we frequently, historically, have thought of North American or European arbitrators for cases that do not have or concern the arbitrator's own jurisdiction. There is no reason why we should not also be thinking about Asian and African and other arbitrators from around the world for arbitrations that may involve their region, but may also involve other parts of the world. And this is particularly true in my mind for emergency arbitrations, where it is unlikely that geography actually matters, although of course there's a consideration of time zones, and generally with an awareness that while travel for evidentiary hearings needs to be taken into account, we have the opportunity now to conduct so much by virtual means, and so much of the pre-evidentiary stages are indeed conducted that way, that geography enables us to have some flexibility if we've selected the right person. Just to add one more piece of the statistics that Alex highlighted, which is that 75% of arbitrators in the ICC system were selected by the parties or the co-arbitrators. 60% of the co-arbitrators are appointed by the parties, and then another 15% are appointed by the co-arbitrators to select the president of the tribunal, often with input from the parties. So as we are focused on diversity, the buck stops here. That being said, it is something everybody has to be focused on. In-house counsel have to be demanding more diverse lists from their outside counsel. Outside counsel have to be focusing on consideration of more diverse arbitrators. And I do believe that that conversation about diversity versus quality is over, because there are so many phenomenal diverse arbitrators now that we just need to be thinking more broadly.
Claudia, thank you so much. And thank you for highlighting that we all have a part to play in this in partnership. Alex, did you want to add something?
Very little to add there. Thank you, Sapna.
Thank you. I think we'll call today's proceedings to a close. All that remains is for me to thank our speakers, Claudia, Alex, and Tejus. Thank you so much for joining us from Paris. Tejus, we look forward to having you on the ground soon in Singapore. I think that definitely deserves its own event. Thank you to Arthi from YAF. Thank you to Andrew and Smitha, our leaders of the ICC Singapore Group. Thank you very much, Karis. Can I also just thank the Singapore Business Federation, in particular, Nisa and Ragini, for their smooth and seamless administration behind the scenes. So my last appeal is to anybody here who's not involved with ICC Singapore. We are recruiting and we look forward to having more and more people get involved. Alex, we look forward to seeing you here in Singapore next year. Claudia, we hope to welcome you to our sunny shores as soon as possible. Thank you very much. Good night, everyone. Have a nice Friday evening. Have a nice afternoon in Paris.
Take care, everyone, and thank you.
Bye, Sapna. Thanks.
Thanks, everyone.
Alex. Bye, Claudia.